So I'm going to say a few words to start. I think it's about that time.
Okay.
We might even break 300 here. We're at 293.
Look at that.
Kim Mcleod is one of the founders of a Facebook page called One More Thing. And that has a certain resonance, I'm sure, for anyone who's a parent of a child with disabilities or special needs. There's always one more thing. And you have a sizable group. I was referred to Kim's Facebook page by a client of mine who's getting family managed funding care and who needed to have a legal guardianship for his child who's approaching 18. The funding can only be given or paid over to the legal representative of the child, and this child is not competent. So we're dealing with that for several of the families. They get funding through their local LIN. And so that referred me to Kim, and I checked out her Facebook page, and it's very interesting. How long have you been going for now, Kim?
We've been up and going for 9 years now.
Wow.
Mm.
It's amazing how many institutions, what they do. I remember some years back, maybe 10, 12 years, I was speaking in Kincardine, and it was the 40th anniversary of the Kincardine District Association for Community Living. And I met in the hall that we had this presentation in with a couple in their 80s and still involved, but they were founding members of the KDACL. And I knew the answer when I asked the question, because typically that's what lawyers do, right? But I asked them, why is it? Why are we here at the 40th anniversary of the KDACL? And the husband said to me, well, 40 years ago, our kids were all getting out of school and there was nothing for them to do.
Right.
So they started up the association and just kept going. And 40 years later, it's an institution, right? So all you got to do is keep it up for another 31 years and you can have another 40th anniversary.
That's right. Yeah.
So Kim, would you care to say a few words about your Facebook page?
Sure. So One More Thing was coined over coffee with my co-founder, Kelly. And, we're talking all the time about that extra thing that we had to do, that extra piece of therapy or that extra piece of paper, or all the tasks that as parents of children with special needs and medical complexities we had to attend to. And so we decided to start getting together with other families. And that, we got together in the living room a few times, and then eventually I put it on Facebook. And there we were. And by word of mouth, families of children who have a physical disability here in the Eastern region and or beyond have heard from other parents about this group called One More Thing. And we can commiserate about the One More Things, but the group's focus is on having compassion and sharing our grief and finding solutions. And it's worked. We have 930 families who are active in there. And it's a great community. People keep recommending it. So
well, this is, as I say, this is just how it works. Families get together, there's a certain need. And that's also how my practice has grown, because I started this, the first presentation I made was to the local Schizophrenia Society chapter, was February 26th of 1996. And what I realized after the session, not that I knew much of anything, was that there was a need for Henson trusts in people's wills. And the bulk of people didn't know that. They didn't know that Henson Trust was a useful tool. And if they did, because some did, they didn't know where to get it done because there were no lawyers who knew how to do it.
yes.
And I remember that some of the first people, that they had gotten a copy of the precedent, the simple precedent from the Court of Appeal, not too much wording in it, but the essential terms. And they had taken it to a lawyer to have one done for them. I said, I want one of these, And the first thing that the lawyer did was act suspiciously that they were trying to somehow circumvent and beat the system. So anyway, it's grown since February 26, 96 by basically listening to the families and seeing as their children aged and as the parents aged and as time went by, what did they need? And so as time went by, we just learned how to provide what those families need. We started doing guardianships, for example, in 2009, because RDSPs came in, and at the time, if your child was not competent, then there was no legal representative to set up the RDSP.
Right.
At that time.
Yeah.
Started doing tax credit recaptures back in 05. You just add these things on as time goes by. So I think I'll start my presentation now. You'll see that there's Diane Verano is blanked out. Diane, could you just say a couple of words and show your smiling face? Diane's one of our associate lawyers. Want to say hello, Diane?
Hi, my name is Diane. I'm one of the lawyers here. I'm glad to be here tonight.
She's going to be in the background along with Karen Christie, who's arranged this, and they'll be answering questions to the best of their ability. Now we have 309 people attending. We had 562 registered, so that's about right. We're slightly over half are taking part. Everyone will receive the recorded video and the PowerPoint slides. And if you know anyone that you think would like to take part in the event next Tuesday at noon, if you forward your copy of the invite to them, then they could sign up for that as well.
Okay.
So my practice specializes on a provincial basis, interprovincially as well, but largely Ontario-based. It's definitely not an Ottawa practice. And it focuses on assisting families with kids and special needs. And we're going to try to get this whole show done in about an hour from now. So I'll just make a start. Kim, as we proceed, if you see things you'd like to comment on or that you think would be something well directed for the theme of the kinds of discussions that your Facebook page members have, then feel free to chime in.
Sure, thank you.
So this will just give you the scope of the situation. The short story is that one family in 10 in Ontario is the parent actually, household of a person with special needs. If you add in the siblings, who will eventually be the trustees, for example, if you presume that it's only one, if there's a family with only 2 kids, and the other sibling is concerned about their brother or sister, well, then it's one family in 5. But we go with 1 in 10. And the way we calculate this is that the population of the province is 13.7 last time I looked. And StatScan says that the way you tell how many households there are is you divide it by 3, which is sort of intuitively got a sense to it, right? Granted, there's a number of single-person households and 4-person households, but they say divide by 3, and that'll give you the approximate number. So you can see that there's 4,566,000 households.
Wow.
And you can also see that if you add up all of these numbers right here, all of them, you get 378,802 people on ODSP. So then you have to take into account the fact that these are people over 18. So it doesn't take into account all the kids under 18.
Right.
And it also doesn't include people over 65 because they're on OAS and GIS. And that's about another third, roughly. So that would bring you up to about roughly 478,000. So you can see that 10% of 4,566,000 is 456,000. So if you have 478,000 kids identified with special needs, well, that's 1 in 10. So it's not really rocket science. And this is the rough breakdown of the kinds of disabilities that the children have. When I say children, obviously, I'm referring also to adult children. But in my practice, the children are still the little boys and little girls of their parents, no matter how old they get.
That's right.
And I'll have to check into these numbers are all from the statistics branch from Ministry of Community and Social Services from ODSP. And I don't see any kind of slice here for autism. So I'm not quite sure exactly where they would fit into that. It's not really a developmental disability. It can have cognitive disabilities, of course. And these are the numbers in any given municipality. So you can see here for Ottawa, there's Ottawa. You can see there's 25,496. And in those households, there are 34,805 people. So they have beneficiaries or other members in the what I call the benefit unit. These numbers, 2024, that's not really truly very representative, but what that is ACSD at the top of the column. That's assistance for children with severe disabilities. And it doesn't really turn on severity. But if you're a child with a disability in a low income household, you can receive up to about $450 a month, while as a minor, instead of the standard amount for an adult from ODSP. So you can see there's a relatively small number that are in that category. It's obviously not truly representative. One of the big things we do, what we do at the start of any intake, is we try to put money back into people's pockets. So we consistently do benefit increases if the child's over 18 and living at home. And here are the numbers for that. You can see here that there's boarders, 48,233. That's the number of people that are on room and board, which means that they're living with parents, family. And 48,000 is about 14% of this number, the 378. So about 14% of all people on ODSP over 18 are at home with parents, and they're all slotted into the 896 room and board. So what we do consistently is we break them out of that into a shelter plus supplementary. We do this by means of setting up a lease arrangement. This doesn't result in rental income for the parent, but so we break it out by having a lease arrangement to deal with the room part, and then we look into the child's ability to shop and cook to deal with the board part. And we're normally successful. There are cases, of course, where the child clearly cannot shop or cook, but in many cases they can. A lot of times it's just that they never have, which is perfectly understandable. You know, if you have a 19 or 20-year-old child with or without some kind of special need, the odds on them shopping and cooking are pretty distant. Mm-hmm. And the other thing we do is we look into the disability and caregiver tax credits, because the disability tax credit, it's surprising how many times families either don't use it or don't know. That's less common these days, but don't use it, or they did. And then when the child went into supported living when they were 28, now they're 38, for example, and the parent at that time thought that the child had to reside with them for them to use the credit, which is not true. And then the other credit, the caregiver credit, that kicks in when the child is 18, and it's a credit of the caregiver, not the child. The disability credit is the child's credit transferred to the tax-paying parent. And you can see here that if we do a backfiling of a 10-year period, which is the most common profile, it recaptures $16,000 roughly for the disability credit and about $9,000 for the caregiver. So this is big money.
And nobody knows about that.
No. And the interesting thing, the fascinating part here, is that until 2017, the only people who could use the caregiver credit were the ones whose child resided with them. So only 14% or 48,000. So of course we did our best to identify this, as clients came to us. But as of 2017, the reside with criteria was removed. So now I would think it's a fair bet that almost all of the 378,000 families are caregivers. It's just that only 48,000 of them have their child at home. So what this means is that now, starting as of 2017, those families can all use that credit as well. And what it does is it reduces your taxes by about $1,000 a year. So this is good, right?
Absolutely.
I mean, you know, if everyone used it, 378,000, it's 378,000 times 1,000 every year.
It helps.
It's a lot of dollars.
Yeah.
So that's very gratifying. Now, when a child turns 18, these are the simplistic indications of how the child could qualify for ODSP. They can't function in a competitive workplace or in the community or handle personal care. These are the benefits that they could receive. And if they're on ODSP, they can receive voluntary gifts from all sources of up to 10,000 over 12 months. And this is as of September 2017. And as of that same date, they can have assets of up to 40,000. It used to be awkward because the gift rule was 5,000 and the asset was 6,000 and the asset test was 5. So the child could receive 6, but could only keep 5.
Wow.
Which is a pretty tight rein.
Mm-hmm.
This is something recent as of September 27th. If you are a parent of a child who is either under 12 of any sort, or if you can't work for at least 50% of your normally scheduled work within a given week, because you have to care for a dependent who, due to COVID, needs your care at home, then you can receive up to $500 a week. And that has recently been extended for another further period beyond the 26 weeks. Now, to get approved for the disability credit, which saves taxes for the parent, then you have to apply. There's a T2201 form. You have to have it filled in and then signed by a doctor. And CRA doesn't like to approve these. So there's a process to this. We have a whole step-by-step process. But it's important. Now, we'll get to the lines for the tax credits in a moment. But one of the big things is that if the child is approved for the disability credit, then they can have a registered disability savings plan, only if they're approved for this credit. So we'll get into that further in a moment. And there is recently a one-time $600 payment for people who are becoming approved for the disability credit. If you were previously approved prior to the end of 2020, you've already received your $600 payment. And if you're approved, as you can see, after that period, for a period of time, you can still receive $600. Now, this is information about the caregiver credit. The caregiver credit is loosely defined, and doesn't have to be approved the way the disability credit is. It can be backfiled for up to 10 years. These numbers vary a little bit because for a number of years it was 600 a year, and then it became in 2012 1,000 a year. So we're gradually getting up to the point where it's the standard 1,000 for each of the 10 back years, but we won't have it all completely up to date until 2022. Now, these are the lines that you check. So if you did use this credit in 2019 or 2020, it would be on line 30450. That's the adult dependent with a disability for caregiver credit. If you use 30425, that'll work too, but what it is the adult dependent. It's just not with a disability.
Okay.
So then you can get approved for the disability tax credit. And if for 20 years, if you don't do anything, taken from when the child is 18, based upon the child's own income, which would be the ODSP income, then even if you don't do anything, if this account is set up, the government will put in $1,000 a year for 20 years. That's something, because of course it's invested. and it sits there until the child is 60, so it grows. But beyond that, what happens in most cases is if you contribute $1,500 a year after the child's 18, then the government puts in a further $3,500 plus the 1,000. So what that means is over a 20-year period, you put in 30,000, government puts in 90, so that's 120. And over that 20-year period, if it was invested at 5%, which is it's doable, no question, then by that time it's over 200,000 after 20 years. So if you started when the kid was 18, now he's 38. And if you leave it there invested until he's 60 at that rate, it turns into about $700,000.
Wow.
And then at age 60, it starts to be paid out to the child directly at the rate of about $32,000 a year. Now they're still on ODSP. And then when they turn 65, they are a senior. So they get OAS and GIS plus the $32,000 a year. And we're told that the payments from the RDSP will not affect GIS. Otherwise, for other income, every dollar offsets 50 cents of the gains supplement. So
Ken, what happens if the child dies at age 50 or 40?
Well, it's their estate, it's their money. Clearly, it's their money. They are the sole beneficiary of this plan. It's their plan.
Okay.
And what happens is the contributions and the growth that have come from the family, they're paid out to his estate. And the grants and bonds, they vest 10 years after after their contribution by the government into the plan. So some of these will be vested by age 50.
Okay.
So they would be kept too. The remainder that aren't vested would go back to the government. And if the child, obviously the child's approved for the disability credit. So it could be purely physical, right? But if it's cognitive, which is the big chunk of the situation, you saw those numbers on that pie chart, then if they're incapable of doing a will, they die what's called intestate. And then by succession law, if their parents have survived, then it goes to their parents. And if the parents have deceased, then it would go to siblings, if any, or the children of the siblings, if any. But then otherwise it goes up the line and over and down. And basically, it's going to wind up in the hands of cousins.
Okay.
Now, it's interesting from my perspective because in lots of cases, those cousins that receive it by succession law may well have never gone to see that kid.
Right.
That wouldn't be impossible at all, would it? But, I console myself because child's gone, parents are gone, there's nobody else, so who cares?
Right.
This is just enough further write-up about what I just said. I'll just leave it on the screen for a few moments. And this is a calculator. You can make your own calculations. It's an easy enough link. Just Google RDSP savings calculator. And if you put in, for example, here, that the birthday was 2000, well, that means and they're approved for the disability credit at 6 because they're diagnosed with whatever. And you then commence the payments when they're 18. And you start out each year with $1,500 invested at 5%. And this is the child's income. This is ODSP. Then this is the amount that it winds up as in 60 years.
Okay.
I mean, who would believe it? It's the power of compound interest, right? Now, you don't need to really read much of this. This just has to do with some of the complexities of the payouts at age 60. This will all be in the slides for everybody who who registered.
At what age can you start investing in an RDSP?
At any age of the child.
Okay. But once they're approved for the disability tax credit.
Yeah.
Okay.
Now, there aren't very many households that have income, not even many single income households that would have income low enough for the parent household for the child to then receive the $1,000 bond. But there are lots of households where the household income is below $95,000. And for those households, if they contributed the $1,500 a year, the child would still get the $3,500.
Okay.
Now, my usual advice is, set up the plan, get on the list, keep track. But if you want to contribute, great. But if you don't, that's fine. Wait till the child's 18. In the following 20 years, you're going to get all of the grants and bonds.
Right.
Surely 700,000 is going to be sufficient for your child. And my experience is that for most households, that 1,500, or if the household income is greater than the 95, then if they put in 1,000, they get 1,000. Well, okay, but a lot of my client families, they've got a place for that $1,000. Again, this is just some embroidery you don't really need to know much about, but it's on the slides. Now, this brings us to a very interesting discussion. Once the child turns 18, they're an adult.
Yes.
So invariably, you're going to have problems with their adulthood, with someone not doing something that you need to get done. Provincial identity cards, Canada revenue tax filings, perhaps disclosure of certain medical information, getting to keep proper track of how they're treated in the supported living environment they're in. It's often not too bad while the parents are alive that they do get cooperation, although there are certain situations where, it's not clear that the child is not competent, and there's a presumption of competence. So what this means is that it's a serious offense to disclose certain information, and it's just better for doctors and nurses and Canada Revenue and other sources that have personal information about the child to not give it to you. So what you do is, if the child is competent or appears to be competent and you get slightly more cooperation, then simply have a power of attorney done for them. It's not that expensive at all. There are lots of institutions that will hang their hat on a power of attorney. And that's all you really want. You want practical cooperation. But there will perhaps come a time when you don't get that cooperation, and especially when parents get to that awkward age where they're getting older, they're concerned about what will happen to their child when they're gone. They either have or fully intend to do wills and Henson trusts to provide for the child. And they realize that whoever comes after them, siblings, if you're fortunate enough, if not other family members, perhaps cousins, they have no standing as legal representatives for the child if the child is not competent. So that means that they can't be the account holders for the RDSP, which is now $700,000. They can't manage the disbursements, which are $32,000. They have no standing with the community living sheltered situation. Doctors certainly won't talk to them. So then it's very awkward. And it's at that point that parents say to me, well, I don't want to leave this problem for the people that have been kind enough to say that they'll take care of my child when I'm gone or be the trustees of the trust. I want to put this in place. So what we do is we have the parents appointed along with, if you're lucky enough, siblings of the child, or perhaps other people, to provide some kind of continuity. Now, the only problem with guardianship applications is that it's expensive. There's legal fees and assessment fees and court filing fees and so on. So we never try to sell it. It's always a matter of, here's how it works. This is what it costs. Are you at the point where you're going to sleep better at night and live longer if you have this in place already and you know it's taken care of? And this is just to clarify that firstly, the parents are not the guardians of the children. They're just their parents. They could be, they are, the substitute decision makers for personal care. That's true. And the trustees of the Henson Trust and the will, they're just the trustees of the inherited asset. They really have nothing to say about the child's own property, or the child's personal care.
I have a question for you.
Sure.
You mentioned earlier that family managed care requires guardianship, or maybe that's just for one family. What if your child is competent and can make their decisions? Do they not qualify for family managed care, or is that a different?
No, they would. They would.
Okay, so they can have power of attorney.
Yeah.
And or a parent could have be assigned power of attorney by their child.
Yeah, that's right.
And
And we're perfectly happy with this. We have no problem charging a lesser fee for the powers of attorney if it gets the client what they need.
Okay, I thought maybe there was the ministry had set something up that is going to be a big hurdle for a lot of families.
No.
But if the power of attorney works for a child,
they're fine.
Okay.
But it's a matter of the child more than understanding. They have to understand, which is sometimes an obstacle. But if they do understand, the light is red, do they appreciate that they can't cross the street?
Right. Yes.
Right? And we try to have a pretty light hand on determining if the child is competent, if such a document will get clients what they need for now. But it all falls apart after the parents die, because the brother, the cousin, the aunt takes this power of attorney along with the child, because if the child has a substantial RDSP, the institution that is working with this RDSP, they're not going to just accept this power of attorney.
Right. Yes.
They want to see the person and get it confirmed that this is whatever it is that's happening. This is what the person wants. So the brother shows up with his sister, and the people that they're dealing with can tell by looking and speaking that the sister really doesn't know what she's doing, and it all just falls apart.
Right.
This is just more information. You can read these from the slides when you get them, but this is all just further details about powers of attorney for property. The substitute decision maker, that could be the legal guardian, could be the person with the power of attorney for personal care. But if neither of those is in place, then there's a tree of who gets to be the substitute decision maker. So this representative from consent and capacity, that just never happens. Spouse or parent. So sometimes there's a spouse of a person with disabilities, but not that frequent. So it's parent typically first, and then if not, partner, spouse or partner. But if not, it's the child or parent of that person, and then a sibling. Oops. And then it could be other relatives. But you can see that as far as you get this attenuation, any other relative, well, on a few occasions we have prepared what we call substitute decision maker packages, and they're heavy, spiral bound, weighty affidavits and proof of birth and proof of parentage and so on. And it starts out with the cover letter from me, and that always helps with my signature on the bottom. And then in bold letters, informed consent, because the medical institutions and the doctors realize that for them to make decisions, they have to have someone who has authority to have informed consent to certain treatments. So, you know, that's prepared by a lawyer. It's got informed consent in bold, and the medical professionals realize that they have to pay some attention. But we've only done a few of those. Essentially, as long as people get what they need for the care for their family member, then, you know, we're happy. But a time may come when you need something a little more heavy duty.
Are these guidelines for the power of attorney and guardianship, are they the same generally across Canada in each province, or is this strictly Ontario based?
Nova Scotia has a slightly, not sure proper term, but they have legislation that allows people with more limited competence still sign representation agreements.
Okay.
It's kind of like a power of attorney, but for somebody who isn't really competent. And
So generally it's the same across Canada?
Pretty
Okay.
well.
Good to know.
Well, what they've tried to do is find a solution for the needs of the child or the person, while trying to not take away their own agency to make their own decisions, which is laudable. You know, I support that, but the bottom line is that they need to be provided for and cared for.
Yes.
This is an interesting thing. As part of our intake process, we have a family evaluation form. And what a lot of people don't know is that if you are, as you can see here, a teacher, an OMERS municipal employee, OPG Hydro, or workman's comp worker, WSIB, you have a statutory provincial pensions. And of course, the pension that you receive can be larger or smaller. Teachers and a lot of hydro workers, nuclear power plant people, they get a high pension. OMERS municipal employees, less so. But what happens is you have a pension, you retire, then you die, and your spouse gets 2/3 of your pension, and your child, your adult dependent child, that's the term, adult dependent child, gets half of your original pension, or can do. If they are an adult dependent person after the second of the parents dies, then they can receive up to half of that pension. So for a teacher who has a $60,000 pension and her husband has predeceased her, which happens 2 times out of 3, so then she has a son who's 54 because she's 84 with autism and at Carrie's place and severely not competent. That child qualifies for this adult dependent pension, but he can't apply or manage it. So of course his sister then, as his guardian, after mom's gone, she will apply for this pension for him. And his needs are very modest. So what happens is she makes a deal with Carrie's place to, because of course the pension is greater than ODSP. So he gets 30,000, not 14,000. So he loses ODSP, but now he has more money. So the sister, as guardian, cuts a deal with Carrie's place for his contribution to his care. And let's say that is 14,000, let's say 15,000. So he's getting, after tax, he gets $27,000. So he pays, let's make it 12,000. So he pays 12,000 to Carrie's place. He's got 15,000 left, but he couldn't spend it. He doesn't need it. So the guardian accumulates it and invests it, that 20,000, for the next 20 years until he passes on. And it's invested and it grows. And then he dies intestate. And by succession law, his sister gets it all. Interesting, eh?
Yeah.
I mean, this is fascinating to me because it's never been the case before that the people in these scenarios would die with a pension of 700,000 or 32,000 a year and have a pension from teachers of $30,000 a year, which they can't spend. When has this ever happened? When was a person with disabilities not in simple poverty?
Right.
Right?
So Ken, I know that this is fascinating. This is fascinating. It is a bit overwhelming though.
Oh yeah.
So if somebody wanted to have time with you, how does that work?
Well, they contact the office. Typically, you go to the website, either download the Henson Trust ebook or the Guardianship ebook, or fill in the family evaluation form. And it's sent directly to me and to Karen. Karen's the person that people would contact. She's on the last slide here. Okay. And that gives us a 2-page snapshot of what could be done that's beneficial for the family. And then we usually reply with, discussing those points by email typically. And then if it's appropriate, we have a short courtesy consult to just discuss the implications of some of the things we've identified, or to clarify things. Someone, we've got a box for, is your child approved for the disability credit? And the one is yes, no, and unsure. Well, maybe we should have a chat about the unsure part,
Mm-hmm.
So that's how it usually goes. And
okay.
It's interesting from our perspective, because if a person fills out the form, we put them on the newsletter list. We've got this side of 12,000 people on our subscription list, but there's always something that needs to be done.
Mm-hmm.
You come across the occasional family evaluation form where everything is done except one thing, like a benefit increase. But typically, what we find is that the client family needs 3 things. They need a will with a trust, okay?
Yep.
They're not using the caregiver credit, okay? They don't have power of attorney for their competent child, okay? Usually what happens is the family gives us some information, and there's several things that need to be done. So the work is parceled down to the people in the team here that, I have people that specialize in each area, and there's always some work to be done as a result.
Thank you.
I won't go into this much. It's just that as of 2021, the trust tax returns are going to be more onerous, and there's more disclosure involved. Even if there's no taxable income, there's more disclosure. We'll do a separate session on just the trust changes soon enough.
Trusts are not the same as a TFSA and a RDSP.
No, they're separate.
They're separate things. Okay. Thank you.
Now, if a person wants to identify if they have a trust of some sort in their will, and lots of people do, about 50%, well, that's not true, about 50% have a will. That number decreases, of course, as people get older, but as a rough number, 50% don't have a will. And then even if they do, if they have a will, the number of people that have a Henson trust in it, even though they know they need one, is very small. I would guess 5 or 10%.
Okay.
And of course, we see, we see these scenarios multiple times every week, every day. So it's very rare to find that other lawyers who may have prepared a basically correct, not elaborate, but basically correct Henson trust, won't have stated Henson trust for John Smith. So their client contacts us and says, well, I know I've got something in my will, but I don't know if it's a Henson trust or not. And sometimes it is correct, and other times it is not correct, but it's never explicitly stated. Now, of course, we make it in bold letters, but the wording you'd have to look for if you have a will with a trust in it is you'd have to see if the trustee has absolute and unfettered discretion, meaning that they cannot be compelled to disperse money. That's one of the reasons that ODSP doesn't get cut off, because the trust is not a liquid asset accessible by the benefit recipient, and also shall not vest. No share of the income or capital thereof shall vest in my said son. And the only interest he shall have should be the amounts actually paid to him or for his benefit. And what this means is that the asset of the trust does not belong to the child.
Okay.
It eventually vests in the residual trust beneficiary, which is most typically the siblings. And of course, most typically the siblings are the trustees, one or more. Well, what this means is that they have an absolute discretion as to whether to disperse money for their sister. And if they have, let's say, an abundance of caution and they don't disperse it, then there would be arguably more left over when the sibling passes on for them. So there's this natural built-in conflict of interest that you have to address with the parents, each time.
Yeah.
And usually the parents know quite well whether their other children are the right trustees or whether they're not. So then if they're not, you have to look a little further afield. And the other one is a reversal of the standard even-handed rule. Normally, the trustee is supposed to have an even hand, whatever that is, between the life beneficiary and the residual beneficiaries. But of course, what you want is you want, if every dollar is spent on the last day for your child, that's fine, right? That's their inheritance. So, there's a reversal of the even-handed rule. But of course, what that also means is that if the sibling who's the trustee doesn't disperse money, he doesn't have to, because there's no even-handed rule, right? It's okay to keep it all for the residual beneficiaries, technically. Now, I've never seen that happen. I've seen situations, not many, but a few, where the parents knew that the two children had always been cats and dogs, all their lifetime, and still appointed the other one as trustee. And it becomes abundantly clear when the parent dies that this was a mistake.
Right.
And they knew that, and when we discuss it, they tell me that, but they do it anyway. Sometimes we try not to allow that to happen, but you can't make a client do something. It's mostly observed it mostly in wills that I didn't do, where somebody's died, and then the beneficiary contacts me, or maybe his wife, and says, well, this just isn't right, and it's not right. But it is important to realize that the size of the trust is unlimited. There is no $100,000 limit. It used to be a very common misconception, but not so. We don't hear it so much anymore. Size of the trust is unlimited, and the disbursements are unlimited. The 10,000 over 12-month rule is money given directly to the child. And then there are cases where child's in supported living and they couldn't spend 10,000 over 12, and they couldn't handle it if you gave it to them. But there are other cases where the trusts are more substantial, and you want that child to live in the same or better standard of living than they did when you were alive, because lots of people die richer than they lived. Lifetime benefit trust, this is especially appropriate if you have a sizable RRIF, which of course you'd firstly designate to your spouse, but if your spouse is deceased, then if you die, your RRIF falls into your estate, sizable, it's income in the year of death, and you pay a big chunk of tax. But the only thing you can do is try to die in January instead of December, so that you have no other income and reduce the taxes. But I don't know very many people that do that.
Right.
But the lifetime benefit trust, it's a special structure that is parallel to the Henson trust, receives only the registered funds. And what happens is the registered funds roll over to the lifetime benefit trust, much as they would to a spouse. But then the only thing the trustee can do is buy a trust annuity based on the lifespan, expected lifespan of the child. And what happens is the trust receives the payments, the annuity payments, but this is a RRIF, so all the payments are income. So all of these income payments are attributed automatically by the Income Tax Act to the beneficiary. So you can see that it would be easy enough, and we'll get to a sample in a moment, to have a sizable RRIF. You die, you pay a big chunk of tax, But if it were paid out over time, the money were paid to the trust, but the income was attributed to the child, you might not pay any tax at all. So you can see here that if you have a $500,000 RIF, let's just say that you die in December and you have other income. And let's just presume that you pay 50% in tax, just for simplicity. I know it's not completely correct, I know that part. But that means that the cost to you is $250. And what happens is your child, your estate, gets $250 and the government of Canada gets $250. So I applaud your generosity. I just don't think it's the right thing to do. So what you do instead is you have it roll over to the LBT. You get a life annuity for this child based upon their age at that time. And of course, we can make calculations in presumption. What we do is, we could plan for the parent dying tomorrow, and get a quote. But what we do normally is we look at the actuarial tables and we find out when we think the parent is supposed to pass on, and then how old would the child be at that time. And then what we do is we have a guarantee built into it. And what you can see here is that based upon the age of the child in this example, I won't go into all the details, it would pay $24,864 a year for a minimum of 20 years. It would go for the lifetime of the child, but if the child died, it would continue to pay. Well, that's not quite true, but the point is, it's all going to be received.
Oh.
And what this means is that the child has a personal tax credit and a disability tax credit of about $20,000, and the income is $24,000. So the amount that is taxable is $3,000. The tax is $708, and over the 20 years, just using that time period, there's the taxes that actually get paid.
Right.
So, I'm not trying to be a stickler. I don't really care if it's 250 grand. You can see that it's substantial, however it works.
Mm-hmm. Again, something that not a lot of people know about.
No, it's very rare. I've tracked it since about 2006. I won't go into the whole story, but it's only had royal assent for a few years now. It's relatively recent, although the legislation was completely passed subject to getting royal assent a long, long time ago. And here's another example. You can see this is for a smaller amount of RIF. This might fit more families, perhaps. And here there's zero tax. This is the verbiage that is used now with respect to Henson trusts and trusts where the beneficiary is approved for the disability tax credit. That trust, if the beneficiary is approved for the disability credit, can be taxed at special rates, marginal rates, by electing to become a qualifying disability trust. Before that, it's just an estate trust, and for 3 years it has graduated rate estates. But what you do actually here, you see this preferred beneficiary election. Until the child is 65, at which point they're clearly not a child anymore, you would simply attribute the income to the child to make use of that $20,000 personal tax credits. So if you had a trust that generated more than 20 grand in income, well, okay, you would still attribute it to the child, but the first 21,000 would not be taxed because of their personal credits. And this might leave some balance, but if you have income of 20,000, that would be like a 500,000 trust at 4%, or a 400,000 trust at 5%. So those kinds of numbers are very common. So you can see that with those kind of common numbers, that it's going to generate income attributed to the child, which is not taxed.
Okay.
Plus, if the child is approved for the disability tax credit, if the trust buys a home, maybe it keeps the family home, perhaps, just talking. If it maintains that home and the child lives in it, if he is approved for the disability tax credit, well, then it qualifies for a principal residence exemption. So what this means is that there's 3 kids. One of them has disabilities and is approved for the disability credit, but is capable in lots of ways, perhaps with supports. And so the family home is perhaps too big for them to stay in, but their share of the estate is big enough to buy a smaller property, a condo, perhaps, small condo, and to have enough money set aside as well to support them living there. And then 20, 30 years later, when they pass on and the trust is liquidated and the residue of the trust goes to the 2 siblings or to their children, the house is sold, it's appreciated in value on a tax-free basis under today's tax regime. I mean, lots of stuff in the paper about taxing principal residences, but that could be a very effective intergenerational transfer of wealth after providing for the child with special needs.
Mm-hmm.
Now, this is an interesting scenario. I always talk about life insurance with clients because there are lots of families who don't have sizable estates. So we discuss life insurance to designate to the trust. And you'll see that it can be a very good investment. If you're a female, age 50, non-smoker, then in simple terms, you're supposed to have a life expectancy of 35 more years. Now, if you make it to 85, you have more years. That's just how it works. But the actuarial expectation is 35 years. So if you buy a universal life policy for just $100,000, because you know that you don't own a home, you're single mother, single father, you're not going to have much left, and you've got 3 children. Well, what you could do is buy this 100,000 or 200,000 policy. Let's say 100,000, and the monthly premium would be 115, which is $13.84 a year. Now the child is living with you, and we've broken the amount of room and board, so they're getting $11.69 a month. So I would say that you could afford that premium once the child turns 18. And in a lot of scenarios, an 18-year-old child's mother is 50, right?
Yep.
So now the child's 18, he's bringing in $11.69 a month to the household. He's a joy to live with. And so mom uses 1 month's worth plus a little bit to buy a $100,000 policy. Now, if you tried to save that amount of money to have 100,000, not forgetting the fact that maybe you won't live that long, but if you wanted to save $13.84, you'd have to save it for 72 years to have 100,000.
Right.
Now, granted, I haven't factored in growth, and I haven't factored in taxation and all these things, because you don't need that. This is just a simple example, but you can see that she's not going to live 72 years.
No.
We know that for a fact. So as an investment, as the kind of investment that a person in this situation can afford, that's a good investment. We're making good time here. This is where we look at questions. So I know that Diane and Karen have been answering questions. I think they probably answered quite a few. We're holding steady. We're at 304 people. We were top down at 326. So the people attending are still interested. So I'm just going to look at some of these questions. Can you see these questions too, Kim?
I can see them, yes.
Question here, can an RDSP be cashed in at age 60 or 65? No. What happens is at age 60, it automatically converts into a plan where payments are made payments out to the beneficiary. And as you can see in the prior example, if it's 700,000, it pays out 32,000 a year for a 23-year period. So that's how that works. You can withdraw up until the 59th year, but of course you have to see whether everything is vested. And of course, you would cease contributing at age 49. You'd wait 10 years to start to withdraw, otherwise at 59, at which point you could cash out in different ways.
Mhm.
And at that point, most of everything would be, of the grants and bonds, would be vested. In a legacy insurance policy, how does one indicate a disabled child as beneficiary? What wording would you use? Well, you don't. You designate it to the trust that is in your will for the child, and the proceeds are paid to the trust for the child. Once my child is in residential care, are they no longer considered a dependent and therefore no longer qualify for an LBT for RRSPs? Not necessarily, because, for example, if the child is in a residential care situation, the odds are good that they are approved for the disability tax credit. And if they are, then in order for this credit, for Canada revenue purposes, for this credit to be transferred to the tax-paying parent, to be transferable, the parent has to continue to help to some degree with food, shelter, or clothing. Now, it's true that the pension plans may have different criteria than Canada revenue, but if you can show that you're helping to some extent with food, shelter, clothing, then this would be dependence. And under the Income Tax Act, the financial test for dependence, on the face of it, is the personal tax credit of $13,229. But of course, ODSP, the maximum is $14,000. So on the face of it, initially, the person would not be financially dependent because the ODSP is slightly greater than the personal credit. But for a person who is approved for the disability credit, it's the personal credit plus the disability credit. So total of about $21,000, which is the financial test in the Income Tax Act for financial dependence. And then beyond that, it's a fact situation. I can see where the question's coming from, obviously. But if you have the child come home with you every other week or frequently, if you help to supply clothing for them, when they're with you, you feed them, obviously. You take them out and buy them food, then I don't see why you couldn't have the child. Actually, I'm sorry, I got off track here. That was for the pensions. I'm very, very sorry. For the LBT, all that it is the child has to have cognitive disabilities. I'm sorry, I got off track because of the residential care. The residential care has nothing to do with it. It has to do with the fact that they're your child. They have to be your child rather than your niece. And they have to have cognitive disabilities. I'm sorry. I thought we were talking about pensions. Let's see what else we've got here. What's a RRIF, and which is better for kids with disabilities, RRIFs or RDSPs? Well, a RRIF is your RRIF. A RRIF is your RRSP when you turn 71. An RDSP is the child's savings plan, and that's separate. I live in BC. Can you recommend a law firm here that would have your expertise? No, I couldn't. But from time to time, we do assist clients in BC. I don't doubt that there are lots of lawyers in BC that can do a basic appropriate Henson trust.
This is a recording. People will get that recording, right?
Yep.
Okay.
If an ODSP recipient owns a house, how does he claim or calculate the shelter benefits every month? Well, it's very simple. You have your shelter costs, all of your shelter costs, whatever they are. And ODSP will give you $11.69 a month with a $496 shelter component. That's it. So as long as your shelter costs are greater than $469, that's what you'll get. That's the part of the problem. From time to time, people inherit money outside of a will, And one of the things they think of is, well, I'll buy a house. I know I can have a house. It's exempt for ODSP purposes. The problem is that if you own the house, how can you carry it? You could move to some small town, perhaps. You could buy a modular home in a mobile home park. You might be able to carry that, but that's the issue. You could buy a home with another person. Where would acquired brain injury, traumatic brain injury fit into the RDSP pie chart? That's an excellent question. Let's just take a look at it again for a second. Would it be diseases of the musculoskeletal system? It's a physical disability, acquired brain injury.
Maybe it would fall under other.
Other physical illness? Yeah, probably, eh?
Or disease of the nervous system.
Yeah.
Like, they call it neurodiverse now. So, which also falls under developmental disabilities, but
I'm not sure.
such a wide span now.
Yeah, and a lot of people have dual diagnosis.
Yeah.
So who knows which slice of the pie they get put into, you know?
And the pie is probably outdated for, today.
Yeah.
So,
If you have an RDSP and a survivor's pension, teacher's pension, would you recommend full life insurance? If you can afford it, it may well be, you'd have to think about whether that supplement is needed. If you had half of a teacher's pension, if you had a $30,000 pension from your mom and you had an RDSP, you're probably going to be just fine. If the RDSP was started at age 18 and then at age 60 pays out 32,000, and then you have a 30,000 pension from your mother. Good question. Do you need 100,000? Do you need 100,000 insurance? Well, the RDSP is a regular annual payment. Teacher's pension is a regular annual payment. It's not capital. It's not something that you could, pay for an emergency for. These are all estate planning questions. It's a good question. Does the individual who claims the caregiver amount have to care for the child full-time? No. Or can they also hold another paying job outside the home? Yes. Now it's going to be 7:15 in a few minutes. Our numbers are slowly dropping. We're at 274. I said that we would go on until about a quarter after. Let's just see one or two last questions. Is an adult living in a group home still considered a dependent age 25? Yes. Can you claim the disability credit and the caregiver credit if your adult child does not live with you and you claim the disability amount for your own disability? Yes. The way it works is you have your disability credit. That's on line 316. If you help the child with food, shelter, clothing, although they don't live with you, then you can still transfer their credit to you. That's line 318. And as of 2017, I talk all day, so by this time of night I get a little scratchy. As of 2017, the reside with criteria was removed. Used to be that they had to reside with you for you to be the caregiver. But if you're using the transferred disability credit, you can surely use the caregiver credit as well as of 2017. We do a lot of backfiling because, as you can see from looking at these numbers, there's 378,000 and only 48,000 at home. So since 2017, arguably, all of those other families could use the credit too. It'll take a few years. It'll take until 2027 for the full 10-year period to be a backfileable period. is the $1,000 per year paid for past years if you just get the RDSP. Yes, for a maximum of 10 years. If you set up the RDSP now and the child was approved up to and more than 10 years ago, then they will get the full 1,000 times 10. At what age should you have a will made up for an adult child with a disability? Well, taking into account whether they have assets or not is a factor, and taking into account the fact that if they die without a will, by succession law, it goes automatically to their parents and then to their siblings. Doing a will once they're an adult, along with their powers of attorney, which are typically more important at that point, if they're competent, doing a will is a perfectly fine thing to do. It enhances their own agency. Perhaps they have personal items that they want to leave. But you'd have to give some thought to whether it's something you want to pay for that you actually need to have happen. And I think I'm going to make the last question this next one. So I'll try to find something interesting. If my son's DTC has an expiry date, and sometimes that's true, it's really a date by which you must try to renew, can we still open an RDSP? Yes. What if it expires and they won't renew it? Well, as of 2020, if the DTC expires and you can't get it reinstated, and if you notify the parties, Service Canada and Mackenzie Financial or wherever the RDSP is, that you want to exercise the 5-year window to try to get the child approved within the next 5 years, then you can continue trying. They don't close out the account. And as of 2020, the RDSPs can stay in place, and even the non-vested grants and bonds are retained. So but you can't further contribute until the child is reapproved. And really, finally, the last one. What is the impact on ODSP and OAS, that means they're over 65, if the child is the recipient of a survivor's pension? Well, if they're getting OAS, they're over 65, so they are not getting ODSP. If they're getting ODSP, not OAS, then if the pension exceeds the survivor's, if ODSP is greater than the survivor pension, which it could well be for an OMERS municipal employee pension, it could be $500 or $600 a month. Well, then they continue to get the OMERS pension plus topped up to $1169, so there's no advantage to them. And if it's a teacher's pension, then they lose ODSP. And I think that is the end of this presentation. I'd like to thank everyone who took part. Everyone who registered will receive the video and the PowerPoint slides. Kim, I'd like to thank you. Hope that you found it interesting.
Yes.
And now you know what we're gonna do all over again next Monday lunchtime.
I like that that at your website you have booklets available, and people can download them, and they can contact your office and consult with you. So I mean, this is very packed information.
It's a lot. It makes your head blow up.
It does. My head's a little overwhelmed, but I couldn't contact you through your website and do one of those packages and have a consultation.
Yeah, that's the simplest. Download the ebook on Henson Trust or Guardianship, and that'll automatically connect you with us. And
fantastic.
And you know, we find that people repeatedly take part in these webcasts. You know, it may be the same topic, it may be a different topic, but we find that people religiously take part in these webcasts.
You have to, because there's so much information.
It is. You just can't grasp and retain it all the first time around.
No. Well, I'm really glad. Thank you very much for offering this to our community at One More Thing, and certainly to everybody that attended tonight. It's fantastic too.
Thank you very much. I'm going to close the doors on this now.
And just quickly, just let people know, we tried our best to answer all the questions. We've answered 150 questions. So if I didn't get to anybody, just email us.
Perfect. And that
Good work,
information
Karen.
on the slide too, right?
Okay, I'm going to stop the sharing and turn it off now. Good night, everyone.
Good night.